The dream of full independence continues to shape domestic politics and international diplomacy and is set to become a key hub for the northernmost highway, a transpolar route that could redefine global commerce. Scientific collaboration serves as a powerful form of soft diplomacy, binding the two nations together through shared research. Is one of a thriving autonomous Greenland, deeply integrated into the North American security umbrella. From the dawn of the Cold War to the challenges of the future, the USA and Greenland remain inseparable. Just the world's largest island, it is a critical geographic pivot point for global security and shipping. American interest began as early as 1867, driven by the same manifest destiny that led to the purchase of Alaska. World War II changed everything. The U.S. established bases to protect the North Atlantic from Axis influence. Known as Pituffik Space Base, it remains the U.S. military's northernmost installation, vital for early warning systems. Navigating this relationship requires constant diplomacy with Denmark and the increasingly autonomous government in Nuuk. In 2019, the strategic value of Greenland made global headlines again with a surprising proposal for purchase. Climate change is dramatically altering the landscape, opening new shipping lanes and intensifying international interest. Russia and China are expanding their Arctic footprints, making the U.S.-Greenland alliance more critical than ever. The future of this relationship will be determined by the people of Greenland as they seek a path between autonomy and alliance. In our next segment, we explore the deep secrets of Pituffik Space Base and the future of Arctic defense. Thank you for joining us on this strategic journey. Stay tuned for more.
Battle for months. On August 1st, 2023, Trump was indicted on federal charges related to efforts to overturn the 2020 election. The indictment alleged conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy against rights. Trump's legal team immediately filed a motion to dismiss, arguing that a former president has absolute immunity from prosecution for actions taken while in office. The argument was that prosecuting a former president would chill the exercise of executive power and would subject every future president to politically motivated prosecutions. On December 1st, 2023, the district court judge rejected the immunity claim. The judge ruled that the Constitution does not grant former presidents immunity from criminal prosecution and that Trump's alleged conduct, attempting to overturn an election, was not an official act protected by any immunity. Trump appealed to the D.C. Circuit Court of Appeals. On February 6, 2024, a three-judge panel of the D.C. Circuit unanimously affirmed the district court's decision. The panel held that former presidents do not have immunity and that Trump's claims were without merit. Trump then appealed to the Supreme Court. On February 28th, the Supreme Court agreed to hear the case on an expedited basis. Oral arguments were held on April 25th, and today, May 20th, the court issued its decision. Hit that like button right now if you understand what just happened. The Supreme Court, in a 9-0 decision, told Donald Trump that he does not have immunity from prosecution. Every legal avenue Trump had to avoid trial based on immunity is now closed. The algorithm decides what breaks through. You decide whether this analysis reaches people who need to see it, because what I am showing you is the highest court in the land unanimously rejecting Trump's argument that he is above the law. At 10:34 a.m., legal experts began reacting to the decision. Former Acting Solicitor General Neil Katyal stated on cable news, quote, "This is a complete and total rejection of Trump's immunity claim. A 9-0 decision means there was no division, no dissent, no ambiguity. The court is speaking with one voice, and that voice is saying Trump can be prosecuted like any other citizen." Harvard Law professor Lawrence Tribe posted on social media, quote, "The Supreme Court has affirmed a foundational principle of American democracy. No one is above the law, not even a former president. This decision removes the last major legal obstacle to Trump's trial." At 11:15 a.m., the special counsel Jack Smith, who is prosecuting the case, issued a statement, quote, "We are pleased with the Supreme Court's decision. The court has confirmed what we have argued from the beginning. Former presidents are not immune from criminal prosecution. We are prepared to proceed to trial expeditiously. We will be filing a motion with the district court requesting a trial date within 60 days. That statement is prosecutors saying they want to move quickly now that the immunity issue is resolved. At 11:47 a.m., Trump's attorney John Lauro held a press conference. He stated, quote, "We disagree with the Supreme Court's decision. We believe the court failed to consider the chilling effect that prosecuting former presidents will have on the presidency. However, the court has spoken. We will now focus our defense on the merits of the charges. President Trump is innocent, and we will prove that at trial." That statement is the defense conceding that the immunity argument is over and shifting to a trial strategy. Drop a comment right now. Tell me if you think this 9-0 decision was the right call or if you believe former presidents should have immunity. I am reading every response because this question goes to the heart of how our legal system treats powerful individuals. At 12:23 p.m., the White House issued a carefully worded statement. Quote, "The Supreme Court has reaffirmed a principle that is central to our democracy. The rule of law applies to everyone. We respect the court's decision and the independence of the judicial process." That statement is the current administration endorsing the decision without commenting on the specifics of Trump's case. At 1:15 p.m., Republican members of Congress began reacting. Some supported the decision. Senator Mitt Romney stated, quote, "The court got this right. No one, including former presidents, is above the law." Others criticized it. Senator Lindsey Graham posted, quote, "This decision will haunt future presidents. Every president who leaves office will now face the threat of prosecution by their political enemies. This is a dangerous precedent." Let me walk you through what the Supreme Court opinion actually says, because the reasoning is important. Chief Justice Roberts, writing for a unanimous court, begins by stating the question presented, whether a former president has immunity from criminal prosecution for conduct alleged to have occurred during his presidency. The opinion then reviews the history of presidential immunity. The court notes that in Nixon v. Fitzgerald, decided in 1982, the Supreme Court held that sitting presidents have absolute immunity from civil liability for official acts. But that case, the court emphasizes, involves civil suits, not criminal prosecution, and it involves sitting presidents, not former presidents. The court finds that the reasoning from Nixon does not extend to criminal cases against former presidents. The opinion states, quote, "The Constitution does not explicitly grant immunity to former presidents. No historical practice supports such immunity. And the concerns that justified immunity for sitting presidents, such as the need to avoid distraction from executive duties, do not apply once a president leaves office." The court then addresses Trump's argument that prosecuting former presidents will chill the exercise of executive power. The court acknowledges that concern, but finds it outweighed by the principle that no one is above the law. The opinion states, quote, "The potential for politically motivated prosecutions is a concern, but that concern must be addressed through prosecutorial discretion, grand jury review, and the requirement of proof beyond a reasonable doubt. It cannot be addressed by granting blanket immunity that places former presidents beyond the reach of the criminal justice system." Share this video right now, because what I am about to explain is what happens next now that the immunity claim is gone. First, the case returns to the district court. Judge Tanya Chutkan, who is presiding over the trial, will now schedule proceedings. Second, prosecutors will file a motion requesting a trial date. Based on Jack Smith's statement, they want trial within 60 days, which would put the trial in mid-July. Third, Trump's legal team will file motions seeking delay, arguing they need more time to prepare now that the legal landscape has changed. Fourth, the judge will rule on the trial date. Given that the immunity issue has been litigated for nearly a year, the judge may be inclined to move quickly. Fifth, jury selection will begin. Sixth, the trial will proceed. And seventh, a verdict will be reached. At 2:47 p.m., the district court issued a scheduling order. Quote, "In light of the Supreme Court's decision, the parties are ordered to appear for a status conference on May 27th at 2 p.m. to discuss trial scheduling. The court expects to set a trial date at that conference." That order is the judge moving immediately to get the case on track for trial. At 3:34 p.m., Trump posted again on social media. Quote, "I will not get a fair trial. The judge is biased. The prosecutors are corrupt. The jury pool in D.C. is 95% Democrat. This is a rigged system. But I will fight, and I will win, because I did nothing wrong." That post is Trump setting up a narrative that any conviction is illegitimate. Here is what we are watching for over the next 2 weeks. 6 indicators that will tell us how quickly this case goes to trial. Indicator 1, what trial date does the prosecution request? If they push for July, it signals urgency. Indicator 2, what trial date does the defense request? If they ask for 2025, it signals delay tactics. Indicator 3, what does the judge decide? If she sets a date in the summer, it means she wants this resolved before the election. Indicator 4, does Trump file any additional appeals? If he appeals the scheduling order or any pretrial rulings, it could delay the trial. Indicator 5, do any plea negotiations occur? If prosecutors and defense meet to discuss a potential deal, it could avoid a trial. Indicator 6. Does Trump's rhetoric escalate? If he attacks the judge or jurors, it could result in sanctions or gag orders. Here are 3 scenarios for how this proceeds. Scenario 1, the trial happens quickly. The judge sets a trial date in July. Jury selection begins in early July. The trial lasts 4 to 6 weeks. A verdict is reached in August or September before the election. This is the expedited trial scenario. It means the legal case is resolved while Trump is campaigning. Scenario 2, the trial is delayed until after the election. Trump's legal team succeeds in pushing the trial to 2025. If Trump wins the election, he could potentially pardon himself or direct the Justice Department to drop the case. If he loses, the trial proceeds in 2025. This is the delay scenario. Scenario 3, a plea deal is reached. Faced with a 9-0 Supreme Court loss and the likelihood of conviction at trial, Trump's legal team negotiates a plea. Trump pleads guilty to reduced charges, avoids prison time, but accepts some accountability. This is the resolution scenario, and while it seems unlikely given Trump's statements, it is not impossible. Subscribe right now, like this video, comment with your prediction. Which scenario happens? I am tracking all 3, and as the May 27th status conference approaches and as the trial date is set, you will see the analysis here. Let me show you why this 9-0 decision is so significant. Supreme Court decisions on major constitutional questions are often divided. You see 5-4 splits, 6-3 splits, close votes. But when the court votes 9-0, it sends a clear message. It means the legal question was not even close. It means that justices across the ideological spectrum, conservative and liberal, all reach the same conclusion. The 3 justices that Trump appointed, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all voted against him. That is significant because it means Trump cannot claim this was a partisan decision. He cannot say the liberal justices ruled against him for political reasons. His own appointees rejected his argument. That makes this decision harder to attack and harder to delegitimize. At 4:15 p.m., a constitutional law scholar at Yale, Professor Akhil Reed Amar, stated in an interview, quote, "This decision is as clear as it gets. The court is saying unequivocally that former presidents can be prosecuted for crimes. This ends a debate that should never have been a debate. The rule of law requires that everyone, regardless of their position, be subject to criminal accountability." At 5:00 p.m., Trump held a rally via video from Mar-a-Lago. He spoke for 37 minutes. He attacked the Supreme Court, the prosecutors, the judge, and the justice system. He claimed the decision was rigged. He claimed he would be vindicated at trial, and he claimed that the prosecution is an attempt to prevent him from winning the 2024 election. He did not take questions. The video ended. What I know for certain right now, at 10 a.m. today, the Supreme Court issued a 9-0 decision rejecting Trump's claim of absolute immunity. The decision was written by Chief Justice Roberts. It was joined by all 9 justices, including the 3 Trump appointees. The court held that former presidents do not have immunity from criminal prosecution. The case now returns to the district court for trial scheduling. Prosecutors want a trial within 60 days. The defense wants delay. The judge will decide on May 27th. Trump has no more legal avenues to avoid trial based on immunity. The trial will happen. The only questions are when and what the verdict will be. This is the Supreme Court unanimously rejecting Trump's core legal defense. This is 9 justices telling him he is not above the law. And this is the final obstacle to trial being removed. The implications of this decision extend far beyond Trump's case. Every future president now knows that leaving office does not grant immunity from prosecution. Every former president will be subject to the same criminal laws as ordinary citizens. That principle has now been established by the highest court in the land. And that principle cannot be challenged or reversed without a constitutional amendment, which is virtually impossible. The 9-0 vote means this decision has institutional weight. It is not a close call that could be revisited by a different court composition. It is a unanimous statement that will guide legal thinking for generations. Stay with this channel. Turn on notifications. On May 27th, when the judge sets the trial date, you will see the analysis here. When the trial begins, when the verdict is reached, you will see it here. This is not over. This is the Supreme Court clearing the path for prosecution. And that prosecution is now moving forward. The decision was 9-0. The opinion is final, and the trial is coming.